log on to another course. So if you don't see me, I'm back and forth.
Okay, thank you. And let's see, Miss Grace, Miss Lewis, do we know who's representing Mr. Green?
Wasn't it Maureen McLeod?
Oh, I have a conflict. Good morning, Ms. Hudak. I have a conflict down here, conflict attorney. I just didn't know which one. So
I've got, Judge.
say it again.
My notes say it's Ms. McLeod.
Oh, okay. Thank you, Mr. White. So Mr. Green will be with you as soon as your attorney gets on the line with us. Good morning, Mr. Richardson. Who are you representing again?
Good morning, Judge. Larry Webster.
And what are we doing with Mr. Webster this morning?
I'd like to have a conversation with the prosecutor assigned. I believe the alleged victim contacted me this morning or yesterday and asked for the link. I sent it to her. She wanted to convey her thoughts about the case to the solicitor.
Okay. Good morning, Ms. Evans Battle. Is position number 24, Larry Webster, your case?
Yes, Your Honor, it is.
Have you been able to talk with the alleged victim?
Her name
Not.
is Kate. Let's see the sticker. Kaylin Evans.
I don't believe. Let's see.
Might be
It looks
under
like
Mary.
there hasn't been any particular victim contact, but
Judge, I see her on the platform right here.
Okay. So you all tell me what you would like to do. Tell me her name again.
Miss Kaylin, Kailyn. Last name is Evans, Evans. It's on the name says it's a yellow M that says Mary Evans Battle. So maybe the solicitor can speak with her. And
I will speak with her. Is there a victim advocate on the line? No. I can speak with her. I can give her my work phone number and she can call me.
Okay. And is Miss Evans, is this you that's here on the iPhone here?
Yes.
Good morning, ma'am.
Good morning.
I appreciate you being here this morning.
You're welcome.
It seems like we have a moment before we get started, Miss Evans Battle. Would you like for me to place you into a breakout room with Miss Caitlin Evans? Or...
Yes, Your Honor, that would be great.
Okay.
Thank you.
Okay, very good.
So,
okay, thank you, Mr. Richardson. Miss Caitlin Evans, I'm going to place you into a breakout room. This is Miss Evans Battle, who is the solicitor in the matter, so that you can speak with her if you choose to.
Okay, thank you.
You're welcome. And let's see, Miss Lewis, would you mind?
Yeah, who want me to be the breakout? ASG and attorney.
Miss Evans Battle and just the iPhone here with Miss Caitlin Evans.
Okay. No problem.
Thank you. And then once you do that, Miss Lewis, if you will,
I'm listening.
if you will give Ms. McLeod a call and see when she's going to be able to join us this morning, I'd appreciate it.
No problem.
I'll text her now
All
too.
right. Thank you, Ms. Huda.
I talked to Ms. McLeod. She is going to talk to Mr. Green now.
Okay, very good. Thank you.
You're
I
welcome.
appreciate it.
Your Honor, while we're doing sort of housekeeping, we do have
Yeah.
a couple of other conflict cases that I don't have notes of anybody assigned, so I just didn't know if we wanted to address that. 20 and 21, Mr. Pitts. And then 25 and 26 and 27, it's two different clients, but they both have conflicts. Nobody is assigned per my notes.
For Pitts, Ms. McLeod is on Mr. Pitts.
Okay.
And who was the other one you was concerned about, Mr. White?
To Webster, I'm sorry, not Webster, Williams and Williams, two different Williams, Melvin and Michael.
Okay, and I know that we're happy to get one assigned to Mr. Williams, Melvin Williams. I'm not seeing one being assigned. And I know there was one that's not indicated that there was supposed to be one. So we'll have to flag that. And the other one has to be flagged also.
Okay, thank you. Maybe once Ms. McLeod gets on with us, we can address it with her.
They're not co-defendants or nothing like that, are they, Mr. White? Are you aware of that? Or
I believe
anything?
they are all on, they're both on the same case. Yeah,
So we have to have two.
Terrell Gaskin is our client in the case, so.
So that means we have to have two. Have to see if Mr. Murphy is available.
He does have one on the calendar today as well, so maybe he will be here.
Okay, we'll see. We can pull them in and see if they can help us out today.
I see South Annex is on the line.
Good morning. Do we have someone that we can take from the South Annex?
Actually, I need to speak with him, Judge. So South Annex could call Quorum 2 here.
Yes, sir. What courtroom are you in?
Quorum 2, it's 612-2060.
New call 3. Courtroom 3.
Can you repeat the number one more time?
New call 2.
You're on mute, Mr. White.
Yeah.
Sorry, 612-2060. 2060.
Oh, gotcha.
Call.
Ms. Evans Battle,
Yes, Your Honor.
would you like now to speak with Mr. Richards?
Yes, if you,
Let's see. Mr. Richardson, are you still on the line with me?
I'm here, Judge.
Okay, I'll place you into a breakout room now with Ms. Evans Battle if you would like me to do that.
Yes, please.
Okay, so Ms. Lewis,
Gotcha.
okay, thank you.
Soon Attorney McLeod logs on, be ready, Your Honor.
Okay, thank you.
Yeah, really.
I don't see her on as of yet. As soon as she gets on.
And she already spoke with him.
Okay, very good. And courtroom 2, just let me know when you're ready to proceed. Okay. Good morning, Mr. Rogalski. Who do we have with us?
Morning, Your Honor. Today, we have Mr. Dunquinta Peacock with us.
Okay, he is position number 19.
Yes, Your Honor. And today we are going to be entering a not guilty plea. However, to my understanding, the case that is 25 CR 006090J does not have a bond attached to it. And given that these are misdemeanors, I did want to make a bond argument for Mr. Peacock today, so that way he could get an assigned bond.
Okay. Ms. Hudak, is this your case or is this Ms. Evans's case?
I'm up to number 14 today, Your Honor.
Okay, so the other solicitors in a breakout room right now, so we will proceed. Is there someone in courtroom 2 that we can take in the meantime while she is coming back online with us? Or would you?
We can go to position 17 and 18, Mr. Mason.
Well, that's also,
That's also,
yeah,
so I put those.
1 through 14.
Oh, okay.
I'm just gonna say, I mean, in terms of,
I'm sorry, Mr. Clements.
You sit in the first row. Yeah. Go to position 8, Mr. Clement.
And this is going to be a negotiated plea.
Judge, so when I got the offers yesterday, I spoke with Mr. Clements. I then emailed Mr. Rhodes about this case. We are willing to enter a plea, but we don't think this is a domestic violence case. He was an employee of the alleged victim.
I agree.
Okay, so we're just having to have it amended to a battery and then do 12 weeks instead of an FBI.
Well, actually, so if you can give me a call, because I would still, I mean, we could go back and forth. I don't think the FVIP is appropriate, but we can, I gave you my cell phone, we can always just talk about it quickly off the record. But I saw some of the things you were, yes.
Okay. I don't have a connection with internet connection here for my computer, so maybe you share. Did you put in the chat?
Sure.
Okay, I'll give you a call. Second.
Okay. Given that both solicitors will be occupied, we will be in recess until one of them is available for us.
And Judge, briefly, Mr. Askew at South Annex, that's going to be a waiver this morning, so you won't be needing to excuse South Annex.
Okay, so positions 2 and 3, Mr. Askew will be a waiver. So, Mr. Askew, good morning. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
Supposedly she sent a number.
Cloud, are you with me?
Are you speaking to me, Judge?
No, I was seeing if Ms. McLeod was there. So since we have some time, we could request
Oh, okay.
that she
Good morning, Your Honor. I'm here.
Good morning, Ms. McLeod. First of all, let's see, the gentleman at ACDC, what's his last name again for me?
Green, Your Honor. His name is Walter Green.
Okay, and what are we doing with Mr. Green this morning?
Your Honor, that would be a non-negotiated plea.
Okay, we'll be with you as soon as one of the solicitors returns. We also had a request for your services on another case this morning. Which one would that be, Ms. Lewis? Or which ones?
There will be Michael Williams or Melvin Williams. They're both co-defendants along with the case that the state is representing the victim in. So we need really two conflict attorneys. So Michael Williams III has two cases on the counter, and Melvin Williams has one case on the counter. He's position 25. And Michael Williams is 26 and 27. The case that's involving the alleged victim for the case that the state is representing is going to be position number 27.
Okay.
Let's just assign her one of those. Which one, Ms.
Well, I guess we can go with position 25.
Okay,
Williams.
so if we can
That's
get
good.
you to represent Melvin Williams, position 25, and we'll have to give you the opportunity to speak with him this morning.
Yes, Your Honor.
And then if
Okay.
Mr. Murphy comes on, he can represent Michael's Williams.
And Ms. McLeod, do you also represent positions 20 and 21, Mr. Raquavius Pitts?
Yes, Your Honor.
What are we doing with Mr. Pitts this morning?
I haven't spoken with him yet, Your Honor, but the issue is he is in South Annex.
Okay, so we'll
And whenever I call there, he can never seem to be available.
South Annex, are you with me?
Yes, Judge, I'm here.
Is Mr. Pitts going to be available for us this morning?
Yes,
Positions 20
he's
and 21?
yes, sir. He's en route now. He'll be here within the next 5 minutes.
Okay, thank you. Just let me know when he gets there so that we can have Ms. McLeod speak with him, please.
Absolutely, Judge.
Very good, thank you. Ms. McLeod, position number 7, do you represent Mr. Travis Buford?
It does. His name does not sound familiar to me, Your Honor. He may be Mr. Murphy's
That's
client.
Mr. Murphy's judge.
Okay, very good. And so that should take care of all of your cases this morning, Ms. McLeod, is that right?
That is correct, Your Honor.
Okay, thank you.
We are now ready for position 8, Mr. Clements, whenever.
Okay. And what are we doing with Mr. Clements this morning?
It's going to be
Yeah, go ahead. Your Honor, it is going to be a guilty plea. He is currently charged with 1 count of battery family violence. The state is going to be amending that battery family violence to 1 charge of battery.
Okay. Good morning, Mr. Clements. I'm Judge Eric Morrow. This is the state all-purpose calendar. Good morning, sir. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
so, Your Honor.
Okay, thank you, sir. You can place your hand down. Yes, Ms. Hulu.
Yes, Your Honor. Had this state gone to trial in this case, we would have sought to prove that on August 9th of 2025, Officer Wilson from the Fairburn Police Department arrived at 113 Shannon Chase Drive. They spoke to Cassidy Semple, who advised that when she got home, she and Desmond Clements entered into a verbal dispute about stolen items. The dispute became physical when Clements pushed Ms. Semple multiple times and struck her on the left side of the face with a closed fist. After that, he left the location through a back door. They were unable to locate him at the time. Ultimately, officers did observe her wounds, and that included a scrape on the left side of her neck and a scrape on the left side of her wrist. Your Honor, the relationship between the two is that he resided there from time to time. It was not a romantic relationship. He served and a number of childcare types of duties and everything like that, Your Honor. So the recommendation in this case is for Mr. Clements for 12 months to serve however many days he's been in at the current 12 months to serve 30 days credit for time served, the balance to be served on probation. No further contact with Miss Cassidy, Cassidy, simple, traditional spelling. We're asking for a stay away from 113 Shannon Chase Drive in the city of Fairburn, and we're asking for 100 hours of community service, Your Honor.
Thank you. Mr. White?
Your Honor, that's the pleas we negotiated. We just asked to accept that. We would ask that he be allowed to report by phone and mail to probation, and he's planning on moving back to New York. So.
Okay. If nothing further, Mr. Clements, it's my understanding that in case 25 CR 005879D, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Sir.
Has anyone forced you or coerced you to plead guilty?
Yes.
I'll accept the plea as negotiated. Mr. Clements, when you complete, I will allow you to report by phone, and when you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, sir.
Thank you, Your Honor.
Judge, may I make an announcement when you get a moment on Mr. Webster?
Yes. Yes, Mr. Richardson.
Ms. Evans Battle and I have, there's another case connected to this case, and that case is reset in Superior Court for the 17th of December. We'd ask that this case be put on the SAP for the 18th of December.
Let's see, Ms. Lewis, can we place that case that far out?
It's on a Thursday. If that's what they like, it can be.
Yeah, that's fine, Judge, because that case, same victim, same kind of connected situation. If we bring a resolution to that one, then we'll probably be able to bring a resolution to this one.
Yeah, we can set it far out. That's fine.
Okay. So we'll reset it to December 18th SAP calendar. Anything further this morning, Mr. Richardson?
Not at this time, Judge. Thank you very much.
All right, very good.
Thank
Have
you,
a good
Ms.
day.
Evans. Take care, y'all.
This is Mr. Webster right here, just so you know.
Oh, yes, good
Mr. Webster, were
morning.
you able to hear?
Yes, I never said it.
What case that we just end with, Judge? I'm sorry.
Okay, that was position number 24 with Larry Webster. That's going to be reset until December 18th with that SAP calendar. So we'll see you back at that time, Mr. Webster. All right, good luck to you, sir.
You ready now for Attorney McLeod's client, position 9 through 11, Your Honor.
Okay. Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Yeah. Okay, you can place your hand down. Thank you, Mr. Green. Let's see. It's a non-negotiated plea, Ms. McLeod?
Yes, Your Honor. What is non-negotiated is the family violence intervention program and anything structured like that. My client's been in jail for a long, long time. I have represented him for years, Your Honor. That is why I'm very familiar with the situation. He does have a diagnosis, and he's just not capable of doing anything as structured as that program. So asking him to do that is just setting him up for failure.
To Ms. Washington, good morning. May I have his history, please?
Yes, Your Honor. There are 7 arrest cycles with multi-state interaction in Alabama and in Georgia. The last arrest was in July of this year for a probation violation. There was also first offender treatment in 2023 for simple battery against a police officer and willful obstruction. It does appear that the defendant is currently on probation for that case and nothing further.
Tudor.
Is it my turn, Your Honor?
Yes, it's your turn.
Look, and I'll weigh in on it. And okay, we'll just start with position number 9, which is 22 CR 006907J. He is charged with 1 count of simple battery family violence. The state's recommendation at that count is 12 months to serve 126 days, credit for 126 days time served. And just close that case out. And that case did occur on October 14th of 2022, Your Honor, when in this situation, Atlanta Police Department they were dispatched to 1605 Stokes Avenue Southwest for a domestic dispute. They met and spoke with Laura Gibson, whose name you will continue to hear throughout this entire recitation. Ms. Gibson stated that her boyfriend, Mr. Walter Green, came inside her room, demanded to have sex with him or with her. Ms. Gibson told him she didn't want to have sex. Ms. Gibson told him no. He got mad. He started to yell. They started yelling at each other. He began hitting her. He hit her with a closed fist and started hitting her on her back and head. They'd been drinking together that night as well. The police searched Mr. Gibson's head to see if there were any physical injuries, but there were none. Ms. Gibson refused to be seen by medical personnel at that time. Mr. Green was still on the scene and he was in their bedroom. Mr. Green was detained at that time. He was placed in the back of the patrol car and he did not want to speak at that time. So that is that case, Your Honor. In the next matter, it is the State versus Walter Green docketed to 22 CR. Oh, no. 23 CR 00802300802J. He is again charged with simple battery family violence. And the recommendation in this case is 12 months to serve 14 days, the balance on probation. The state has made a recommendation of no further contact with Laura Gibson, although there's every reason to believe that he and Laura Gibson are likely still together. The offense date in this case was February 8th of 2023. And in this case, again, the City of Atlanta police officers were dispatched to, again, 1605 Stokes Avenue for a person injured call. Upon arrival, they observed Mr. Green laying on the floor inside the location, bleeding from his mouth and nose. Atlanta firefighters from Engine 25 were providing medical attention to him. He was being assessed. Officers spoke to Ms. Gibson, who was on the scene, along with her son, Antonio Chambers. Ms. Gibson said that she had gotten into a verbal altercation with her boyfriend, Mr. Green. During the altercation, her son, Antonio Chambers, overheard the verbal argument and attempted to diffuse it. Soon after, Mr. Green started to throw multiple punches towards Mr. Chambers multiple times, and Mr. Chambers threw multiple punches at Walter Green, landing a hit to his face. Once Walter Green was punched in the face by Mr. Chambers, he was pushed back several feet and went forward towards Mr. Chambers, throwing multiple punches, kicking him in the chest, knocking him around, multiple boxes, and all sorts of melee within the house itself. And so that's the situation that occurred in this instance, Your Honor. And then at the case at position number 11, docketed to 21 CR 007300J, he is charged with 2 counts, disorderly conduct and simple assault family violence. The recommendation in this case at the disorderly conduct is 12 months to serve 6 days. The balance on probation, we are asking for 24 weeks of the FVIP. I will say that the initial recommendation has 40 hours of community service. I would not be asking for that because I think if he could successfully complete a family violence intervention program, that it would be more than enough. No further violent contact with Laura Gibson. At the simple assault family violence, we would ask for 12 months to serve 6 days balance on probation, and we would ask for that to run concurrent to count 1. This incident did occur on 12/4 of 2021. In this case, officer had the state gone to trial, officers from the Atlanta Police Department would testify that they responded to 1605 Stokes Avenue. Upon arrival, they met with Mr. Walter Green, who again was on the front steps saying he got beat up, and he asked for an ambulance. There was drinking going on, not only with Mr. Green, but Ms. Gibson. Ms. Gibson said that Mr. Green was drinking and smoking weed. Ms. Gibson said that she brought Mr. Green and herself some earpieces, and Mr. Green had already destroyed his. Mr. Green wanted to use Ms. Gibson's earpieces, but she said no. Ms. Gibson stated that Mr. Green then actively, violently moved towards her and said that he will put a bomb in the residence. Ms. Gibson stated that he broke her lamp and had a knife on the table, but did not point it towards her. Ms. Gibson said that Mr. Green did swing a baseball bat at the bedroom door, but didn't do any damages. Ultimately, Mr. Gibson or Mr. Green's injuries were then called by Mr. Chambers, again, the son of Ms. Gibson, who intervened upon hearing the threats and did punch Mr. Green in the face, kicking him on the side and throwing him outside, which is where the police ultimately found him. So with that, the state would rest. And Your Honor, I understand Ms. McLeod's position that she doesn't believe that he's going to be successful in completing any programming. But if nothing else, this is 3 instances where police are consistently going to the home to intervene in domestic disputes that end in violence somehow. And so I would say that even if the court does not find that the entire FVIP program is appropriate, maybe taking some steps to address the alcohol usage in the home or just some basic anger management steps might be at least an effort to address the issue.
Thank you, Ms. Hudak. I appreciate it. Yes, Ms. McLeod.
Your Honor, my client, as I said, he has a formal diagnosis, and I have been trying to get him into mental health court. I think he did have an incompetent evaluation at one point in time. So his skill sets for certain things are just not there. And that is what the point I was trying to make. He is quite willing to do just about anything that the court orders. It's just that he is somewhat limited, Your Honor. So asking him to do something as structured as a 24-week program is probably not going to happen.
Is he and Miss Laura Gibson, are they still together?
He told me as a senior for a while, but then he's been locked up for a while. But in my past experience with her and him, they have known each other for a very long time. I think they both have some kind of diagnosis, and they've been together for a while. And I believe the state's recommendation was no further violent contact.
I have no further contact on.
I mean, it's the paperwork that was sent out said no further contact. And I'm sure that, like, realistically, that is probably best for society, but
whether he's actually going to be able to do that,
right,
given
right.
his situation.
Yes.
So, Ms. McLeod, I think I agree with Ms. Hudak that at the very least, I want him to have an alcohol drug evaluation and treatment if necessary, and to be monitored so that he does not, if his problems are exacerbated by alcohol, then I don't want him to have any alcohol. And if he doesn't have alcohol, that might help with the problems that have been going on with Ms. Gibson. So my sentence, if he chooses to accept it, would be, I'm going to have him on probation the entire time. I will waive the probation fees to help him stay on his feet. I want him to have an alcohol drug evaluation and any treatment that's necessary if it is. And I want him to have random screens while he is on probation for alcohol and drugs.
Yes, Your Honor.
Your Honor, and I don't know if this would help or hurt, but it looks like he might be on supervision with Fulton County Superior Court right now. And so if there's any way the court could maybe put in his sentence, if he's screening through Superior Court probation, that misdemeanor court probation would accept that, just so that there's not a duplication of supervision that is going to get him further behind in success, if that makes sense.
Do you know anything about the supervision from Superior Court, Ms. McLeod?
I do know, Your Honor, that he had a Superior Court case, which was, and I think it has now been resolved. That's about all I know about it.
I can just tell you that on December of 2023, he was given 4 years probation, and that's at 23 SC 190332. And that was simple battery against a police officer and willful obstruction of a law enforcement officer. It looks like he's under first offender for that. But if he's being supervised and has some requirements there, if misdemeanor probation would coordinate with their Superior Court probation colleagues. Yeah, I think they don't.
Okay, do we have anyone on from probation this morning?
Good morning, Your Honor.
Good morning, Ms. Allen. Have you been listening to the conversation?
Yes, I have. That would not be an issue. Once he provides us with copies of the screens. Typically, we do coordinate with the felony probation department and get copies of it for our records, so that wouldn't be an issue at all.
Okay, very good. Thank you. All right, so Ms. McLeod, that would be my sentence. I would accept the terms for position 9 and for position 10, and for position 11, it would be what we just articulated. Is that something that he's interested in accepting?
Yes, Your Honor.
Okay. If nothing further, Mr. Green, it's my understanding that in case 22 CR 006907J, you wish to plead guilty to simple battery family violence. In case 23 CR 000802J, you wish to plead guilty to simple battery family violence. And in case 21 CR 007300J, you wish to plead guilty to disorderly conduct and simple assault family violence. Is that correct, sir? Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea, Mr. Green, and the negotiated for positions 9 and positions 10. For position 11, I'm going to require that you do have an alcohol drug evaluation and treatment and random screens. And I'll have you have no further violent contact with Laura Gibson. Okay, good luck to you, sir.
Yes, sir.
Thank you, Your Honor.
Question. The L-shift and the 40 hours taken away.
The only requirements that he's going to have while being on probation would be the alcohol drug evaluation and treatment and the random screens, Ms. Grace.
And no further violent contact, correct?
Yes, that's correct.
Thank you.
Okay, thank you. All right, thank you, Officer Melton. Let's see, who do we have next?
We have position 5, Mr. Brownie.
It's going to be a negotiated plea.
Yes, Your Honor.
Is this your case, Ms. Hudak?
I think it is. Who are we at?
Position number 5.
He's also the add-on.
Oh,
Oh, Mr. Browning, okay, yes, Your Honor.
Okay, and it's my general practice, Ms. Hudak, and it's up to you, but if it's a negotiated plea, I don't require that you recite the facts. So
Oh,
if you'll just give me the
wonderful.
if you'll just give me the negotiated, if it's not a negotiated plea, then I do want to hear the facts, but if you all have negotiated it, you can, if you choose to, you don't have to do the
Oh.
recitation, okay?
I am happy to not give you the rest of it.
Okay.
Sure. Okay, Your Honor.
Okay, just one moment. Let me address Mr. Browning. Good morning, Mr. Browning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Yeah. Okay, you can place your hand down. Thank you, sir. Yes, Ms. Hood.
Okay, so Your Honor, at position number 5, we have Mr. Justin Browning, docketed to 25 CR 006063B. He is charged with 1 count of criminal trespass. We are going to ask that he plead to criminal trespass, and the recommendation in this case is 12 months probation. And we are asking during that period of probation that he stay away from 1100 Welch, WELCH Street in Southwest Atlanta, and he have absolutely no contact with Miss Monique Johnson, MONIQUE, who is an ex-girlfriend of his who wants nothing to do with him. And I guess it would be 12 months to serve, 9 days credit for, or give him credit for any time he has in that case, Your Honor. And then at the add-on as well. So the FTA, we will submit a null pros in that situation. At position number 2, he is charged with expired tag. He is also charged with DUI, less safe, 1 count of attempting to misrepresent tag, and then 1 count of possession of an open alcohol container. At count number 1, we are going to amend that to a count of basic rules. And we are going to offer a period of time served in that. I believe it's approximately 90 plus days. And perhaps the public defender can give me the better number and everything, but I think it's like 90, 91 days. And then we are going to dismiss the remaining 3 counts, Your Honor. So it's just basic rules.
So, what about the DUI?
I know, right? It's surprising. So, Your Honor, he was actually my case back when he was assigned to a courtroom. And I had the opportunity to review the investigation in this case. And in fact, there was no investigation regarding the DUI. So prior to his bond forfeiting, I had actually offered to dismiss that DUI count altogether. And had offered the basic rules. So it just was sort of fortuitous that I happened to be assigned to this calendar today. So the DUI is completely being dismissed.
Okay, so just criminal trespass and basic rules.
Yes, Your Honor.
And okay. All right, thank you. Mr. White?
Your Honor, we just asked you that you accept the plea as negotiated with stipulate to a factual basis. And I would add, since on position 5, there is actually nothing for him to do, that we just call that balance suspended. That makes sense, because it was probated. We'd agreed to probate it because we thought he was going to be doing some probation with DUI.
I understand. Ms. Hood, normally if we have a stay away and no further contact with nothing further, the solicitor's office will agree to balance suspended.
Whatever the court sees fit, my concern is that his behavior was border, if he had done it on more than 1 occasion, it'd be stalking. So as long as the victim has recourse in criminal courts, that if he does have contact with her or goes anywhere near her property, that it will be a probation violation. We don't have any objection to that, Your Honor.
Anything further, Mr. White?
Nothing, Judge. I was just explaining to my client that even with a suspended sentence, if he violates those terms, that they can bring this case back, have him serve out the term, and then add additional charges. So he understands.
Okay, very good. All right, if nothing further, Mr. Browning, it's my understanding that in case 25 CR 006063B, you wish to plead guilty to criminal trespass. And in case 19 DF 004665Y, you wish to plead guilty to basic rules. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
Okay, you understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the pleas as negotiated, Mr. Browning. Good luck to you, sir.
Okay, Judge.
Yes, Ms. Grace.
We're about to go over these pleas again. I got position 5. That is just basic rules. And is it,
Position 5, he's pleading guilty to criminal trespass.
okay, yes, I'm sorry, yes.
Okay,
That's
and
suspended, correct? 90 days.
that'll
Yes.
be, yes.
Okay, that was suspended. On the basic rules, can you just give me that one? And the rest is gonna be non-pros, and you're sending over the non-pros order, correct?
I sure will be. Yep.
Just wanna be on one accord. So can you give me the conditions for the basic rules? 12 months,
Just time served.
time served. I heard that at first and I thought you changed it. Thank you.
Okay. All right, very good. Let's see, who do we have next?
We have position 12, Mr. Hancock.
Also a negotiated plea?
It is, Your Honor.
Good morning, Mr. Hancock. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, thank you. You can place your hand down, Mr. Hancock. Yes, Ms. Hizzard.
Okay, yep, there we go. Your Honor, this is Mr. Hancock. He is charged with 1 count of battery. The recommendation in this case was 12 months to serve 90 days, credit for time served. The balance to be served on probation. No further contact with Mr. Roderick Powell, Roderick Powell, Powell. We're asking for a stay away from 3601 MLK Junior Drive in Northwest Atlanta. That is the location of the incident, and 12 weeks of anger management. And nothing.
Thank you. Mr. White?
Your Honor, I see you accept the pleas negotiated. Mr. Hancock, I understand he has another 31 days in jail based on our calculations. I know we're not putting that officially on. We would ask that you waive 3 months of probation fees and allows probation to terminate or go non-reporting once he completes all of his requirements.
Okay. Mr. Hancock, it's my understanding that in case 25 CR 006062G, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Hancock. I will waive 3 months of the probation fees to help you get on your feet when you get out. And once you complete the terms, I'll have it go to a non-reporting status. So the sooner you get the anger management done, the sooner you won't be on reporting probation and have to pay those fees, okay?
Sir.
All right, good luck to you, Mr. Hancock.
So,
Thanks, Marlon. Excuse me, did you get my?
Yes, Ms. Hill. Say it again?
Did you get my message regarding about Mr. Murphy?
No, I did not. Let me take a look. Did he report on his other case?
He's in court right now with Judge Mather. He'll try to get back on the line, but he said the case he will represent position 26 and 27, but he would like it to be reset to next Tuesday.
On position number 26, has that already been accepted by the DA's office? And Ms. Evans Battle, is that your case?
Yes, I know that one of them was accepted and
Right,
one
so
was not.
have I signed the order on that case as of yet? Do you know?
I don't know, Judge.
Okay,
I do not see one in the system yet. I don't see it attached to the calendar, to the case. That's
Okay,
for position 26 for Michael Williams. It's supposed to be transferred to the DA's office.
all right, then I'll get a transfer order.
No, I do not see one posted in the system yet.
What about my client, Melvin Williams? He
okay,
was-
hold on one second, Ms. McLeod. Let me finish up with Michael Williams first so that I don't confuse myself, okay? And we're gonna reset position 27 until next Tuesday, which is the 21st.
That's correct.
Okay,
I said both of them until we get the order, because I don't see the order. You do have the order,
okay.
Ms. Battle?
So,
I don't have it. I'll have to draft it.
See, we just put them
Okay.
on until we get both of till we get the order, just to be on the safe side.
okay, very good. And let's see, so back to position 25, Ms. McLeod. You have not spoken with Mr. Williams as of yet, is that right?
I have spoken with him, Your Honor.
Oh, okay, and what are we gonna do with him this morning?
He is interested in accepting the state's plea offer.
Okay, so once he gets before us, we will do a negotiated plea on him.
Yes, Your Honor.
Okay, thank you.
You're welcome.
Let's see, who do we have next? Can we take anybody else in courtroom too?
Judge, we have an add-on number 5, Mr. Foster.
Your Honor, this isn't negotiated plea. This is actually reset from last week where we were going to enter a plea. He's going to be released to the ad program tomorrow, so we had to get that worked out. So that's why he got reset from Thursday until today. And I'm not sure if the state has the agreed upon plea terms.
Was there other than what was sent out, was there another, did you speak with another prosecutor?
Yes, well, we were all set to enter the plea Thursday. And because of the housing issue, he had to be reset. He will be released tomorrow morning to Pat. And I grabbed the wrong set of notes. I thought I was grabbing the notes from him. So, but it was in essence a time served plea. But it would have been on the 10/14 calendar.
Okay, well, I have a recommendation for, it's a straight probation case. And with a stay away from the Chevron gas station.
So just to stay away.
Yes.
Okay, so wouldn't
yes.
actually be probated. And that's what we had agreed to last week.
So it's a time served plea with a stay away from the Chevron on Washington Road, and he's going to be released to PAD tomorrow.
Right.
Okay.
That's agreeable, Ms. Evans Battle?
Yes, Your Honor.
Okay.
Thank you.
Very good. Good morning, Mr. Foster. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Is that a yes? Okay, thank you, Mr. Foster. You can place your hand down. If nothing further, Mr. Foster, it's my understanding that in case 25 CR 005574B, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Mr. White there. Are you happy with what he's done for you?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Okay.
That's a yes or no for me.
Yes. Yes.
You understand? Has anybody forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Foster. You know you can't go back to that Chevron, right?
Yes.
Okay, so don't go back there. All right, good luck to you, sir.
All right, thank you, Judge.
And is that 33 days, Mr. White?
Sorry?
Is it 33 days for the time served on Evans Battle? Is it 33 days?
Yeah, I've got 29 days as of 10/10, so yeah, 33 days.
Thank you.
Yeah.
So who do we have?
We have position 25, Mr. Williams.
Okay, and Ms. McLeod, this is going to be a negotiated plea, is that correct?
That's correct, Your Honor.
Yes, good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can place your hand down. Yes, Ms. Evans, Battle.
Yes, for count 1, it's 12-month probation concurrent with count 6, that he complete the OP 21 law and decision making course. Count 2, 12 months probation concurrent with count 6. Count 3, 12 months probation concurrent with count 6, that he complete 60 hours of community service. Count 4, 12 months probation concurrent with count 6. Count 5, 12 months probation concurrent with count 6. Count 6 is 12 months probation, 90 days, credit for time served, back to probation, that he complete a 12-week anger management, have no further contact with Terrell Gaskin, and that in count 7, 12-month probation concurrent with count 6, that he complete an anti-theft course. And I don't know if Mr. Gaskin is still incarcerated or not, but he still have no contact with him.
This happened while in the jail?
Yes, Your Honor.
Okay. Ms. McLeod?
Yes, Your Honor, that is our understanding of the terms of the plea. And we stipulate to venue, identity, and the factual basis for purposes of this plea.
Nothing further. Mr. Williams, it's my understanding that in case 25 CR 006055H, you wish to plead guilty to 2 counts of escape, 3 counts of interference with government property, simple battery, and theft by taking. Is that right?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty? Okay, I'm gonna accept the plea as negotiated. Mr. Williams, I am also gonna require that you be on probation the entire time, but I'm gonna waive the probation fees for you to help you get and stay on your feet while you're on probation, okay?
Your Honor, my client wanted to find out what, if anything, was holding him in jail other than this case. And I was not sure.
I don't know. Does anyone know
Right now,
what's
let you know.
okay?
I didn't hear what was said.
She's looking it up, Mr.
Okay.
McLeod.
He has a hold on him for another county.
Okay.
So this, and plus he has also he has to make a bond on a felony case of
Okay.
$2,500. This will take care of the majority of the charges that are on his counter, but he'll still have a hold and he still have
Okay.
an FTA on a felony charge, and he has have to make a bond on another felony charge. So he'll still be sitting in jail.
Okay. All right. Thank you. I just wanted him to be aware.
You got a question, you on a whole for what county?
Know what county that hold is from, Mr.
One
Lewis?
second, I'll let you know. Let me see if they got it posted.
I got a whole for what county?
Let's see if they got. It doesn't say, it just says a foreign hold with other law enforcement agency. It doesn't indicate specifically which one. It just says law enforcement agency outstanding warrants. So they have not posted what warrants they are, what agency it is, but you do have a hold with several law enforcement agencies. That's what they got on here.
Good luck to you, Mr. Williams.
Thank you, Your Honor. And Your Honor, I'm going to speak with my client in Union City, and then I will be back on.
Okay, very good. Thank you, Ms. McLeod.
You're welcome.
Who do we have next? Can we take anyone else in courtroom 2 right now?
No, Your Honor, we can be in a brief recess until Mr. Rogowski gets back.
Oh, okay, thank you. Just let us know when you're ready to proceed.
Yes, sir.
Okay. I have an announcement while we're waiting.
Okay,
Position one, was set to be a negotiated plea, but, he is apparently being released, so he bonded out, so just be, further notice.
okay.
Excuse me, Judge. This is Sergeant Jones at South Annex.
Yes, Sergeant.
I still have a Mr. Buford waiting and a Mr. Pitts.
Okay, we are, Mr. Buford, we're waiting for both of those are conflict attorneys. So, I'll get with
Yes,
you
sir.
as soon as possible. Mr. Murphy is in another court and we're waiting him back, and I believe Ms. McLeod is on the line with, speaking with someone. So I'll let her know that, her client is also available. Thank you.
Yes, sir. Thank you, Judge.
Judge, we're ready now.
Okay, where to next?
Position 14, Mr. Kilo.
Could be a negotiated plea.
It will be, Your Honor.
Okay.
Yes,
Morning.
Your Honor.
Good morning, Mr. Kellum. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Huda.
Thank you, Your Honor. Mr. Kellum is currently charged with 3 counts, loitering and prowling, public indecency, and 1 count of willful obstruction of a law enforcement officer. There is what the state sent over. I'm going to modify that slightly. I'm guessing that the public defender will not have an objection to that. But ultimately, at the loitering and prowling, Your Honor, I'm going to ask for 12 months to serve 12 days, credit for time served of 12 days, or however much time he has. The balance to be served on probation. I'm asking for a behavioral health evaluation and treatment and a stay away from 514 Sunset Avenue, Atlanta. That's the Sunset Apartments, Your Honor. And 40 hours of community service. I'm going to dismiss the public indecency and the willful obstruction of a law enforcement officer.
Hence, is totally fine with all that. ASP Hudak was certainly correct.
Okay. Anything further, Mr. Rogowski?
Judge, we just ask that you do accept this plea, and those terms are certainly acceptable with the defense.
Okay. Mr. Kellum, it's my understanding that in case 25 CR 0059990C, you wish to plead guilty to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Sir.
I'll accept the plea as negotiated, Mr. Kellum. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Sir.
Thank you.
The only terms is the BHET, correct? And the stairway.
Correct.
We have position 22 next. Mr. Sykes.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Skikes. I'm Judge Eric Morrow. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me, sir.
Yes, sir.
Okay, thank you. Yes, Miss Evans Battle.
Yes, Your Honor, the recommendation is 12 months probation that he received credit for time served from September the 27th of 2025. That he goes back on probation and complete an anti-theft course, that he have no further contact with Marta Perillo, and that he stay away from 817 Gertrude Place Northwest in Atlanta. It doesn't appear that she's asked for restitution in this particular case. And we would just ask that they stipulate to venue, identity, and factual basis for the plea.
We will we so stipulate for the purposes of today's plea.
Any further, counsel?
Judge, we would just ask that probation either terminate or go non-reporting after the completion of the conditions.
Okay. Skikes, it's my understanding that in case 25 CR 006015B, you wish to plead guilty to theft by taking. Is that correct?
Yes. Yes.
Are you under the influence of any drugs or alcohol this morning? I'm sorry, was that a no?
No.
I still didn't hear
It
you.
was a no, Your Honor.
Okay. You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yeah.
One forced you or coerced you to plead guilty?
Yeah.
Listen to my question. Has anyone forced you to plead guilty? I didn't hear his response.
No.
Okay, I'll accept the plea as negotiated. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
Excuse me, Judge, Ms. Evan Battles, can you tell me how many days? You have to have that file paperwork.
My understanding, Ms. Grace, that the solicitor's office is no longer providing dates, so
Not for the
just
credit time served, but the days that he's already been in, not for the confinement, not for the credit for time served, just the confinement. So is it 18 days?
If that's how many days he's served.
Okay. That's the part we have to have, Judge, not the credit for time served anymore.
so you're asking for 18 days, Ms. Battle.
Yes, Your Honor.
Thank you.
Who do we have next?
Oh, we have position 15 and 16. Mr. Martin.
And Ms. McLeod, have you had the opportunity to speak with your client that's at the South Annex?
I have, Your Honor.
And what are we going to be doing with him today?
It's a negotiated plea, Your Honor.
And is that Mr. Pitts?
Yes, Your Honor.
Okay, so I'll be back with him. And courtroom 2, tell me again who this is.
Mr. Martin, position 15 and 16.
Okay, thank you. Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Martin. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can place your hand down, Mr. Martin. Ms. Evans Battle?
Sure.
You're on mute there, Ms. Evans Battle.
Yes, in case number 24CR000642Y, the recommendation is for 12 months probation, serve 40 days, credit for time served, back to probation. The BHET, stay away from 1960 Wells Drive, Southwest Atlanta. No further contact with Donald Shaney, that he pay restitution in the amount of $350, and that he complete 40 hours of community service, that he stipulate to venue, identity, and the factual basis for the plea.
16 will be Norcross upon taking the plea.
Yes, Your Honor.
Yes, Mr. Rogowski.
Yes, Your Honor. So for the purposes of this plea, we so stipulate to venue ID factual basis. I do just want to put on the record, I believe that if I am not mistaken, I believe that Mr. Martin had served from February 5th to February 7th, which would have been a 2-day stint here, as well as from June 24th to July 3rd, which would have been a 10-day stint here, as well as from the 2nd of this month, from the 2nd of October, to now, which would have now been 12 days here. So I would just like to get some clarification to ensure, because part of what's really important for Mr. Martin here about this plea is just ensuring that he does not have more time to serve here, because he has his nephew who he has to go back and help take care of. He also is a truck driver. Oh, that's right. I was just going to say, I apologize. I'm mixing things up here. His nephew was recently passed, and the funeral's on Thursday, and so he is trying to get back to support his family during that time. So if we could get a clarification, I apologize, whether or not this would have sufficiently been his time with the 2-for-1.
Well, that's not something that the solicitor is going to calculate. I don't have privy to that. And how much time do you have that he has? Ms. Evans Battle, was this contemplated to be a time served plea?
It appeared to me, because it was 40 days, I anticipated that it would have been, he would have completed the time, because that's an odd number of days. So whoever calculated it, I expected that would have been allowed for him to be released.
Okay, and that sounds good. Thank you. I just wanted to double check, because I really just wanted to make sure he's able to go home for this funeral. So we don't have anything further, Your Honor. We would just ask, I suppose one further thing. We'd ask that this go non-reporting after completion of conditions, as well as if he would be able to virtual report. He is a truck driver. He is often out of state, and that is his only way to make a living. So I don't want him to get caught up with not being able to report if for some reason he's out on the road.
Okay, I can have him report by phone. That's fine with the board.
Thank you.
All right, Mr. Martin, it's my understanding that in case 24CR000642Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor. Thank you.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. Mr. Martin, when you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to be on reporting probation.
What's going on today? I mean, well, as soon as the jail release me.
Oh, he has a hold.
I mean, I know that I'm gonna pay traffic ticket. I'm gonna pay that traffic ticket as soon as I'm done here. I just wanted to know about here. That's it. It's Clay. Clay County is just a traffic ticket. I just wanted to know would I be being released from here so I can go pay that one. That's it, Your Honor.
All right. Good luck to you, Mr. Martin.
Am I being released? I mean, I
Judge, for this case, we just is there a restitution on this amount?
300, was there a restitution, Ms. Evans? I have down $350 to be paid to Donald Cheney.
Yes, that's correct.
Can you make sure you send that restitution
Community
information
service
to
stands
Ms.
as
Grace
well.
for record, for record purposes? She just need to make sure the name of the information of the victim, so JCS can get that information.
I was just making sure. And the 40 hours community service remain as well, correct?
Yes.
Okay. Thank you for that clarification.
Okay, so I'm good.
Yep.
Yes.
Yes, thank you, guys.
All right. Good luck to you, sir.
Yeah, same to you guys.
Thank you, Your Honor, and thank you,
You're
ASG
welcome.
as well.
Who do we have next?
We have position 13.
Oh, can we take the South Annex case? Is that okay?
Yes, okay.
Okay, is this Mr. Pitts at the South Annex?
Yes, Your Honor.
Okay. Good morning, Mr. Pitts. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, that's to 22 CR 00538-6G. There's a time served recommendation for the charges of loitering, possession of marijuana, willful obstruction of a law enforcement officer. And as to the battery charge at 25 CR 0057779J, it's also a recommendation for time served on that particular charge. Do I need to give you the days?
We can just, I believe time served will be sufficient. Is that
Thank
correct,
you.
Ms. Grace?
Yes, sir.
Okay. Anything further, Ms. McLeod?
Nothing further, Your Honor.
Mr. Pitts, it's my understanding that in case 22 CR 005386G, you wish to plead guilty to loitering and prowling, marijuana possession less than an ounce, and willful obstruction of law enforcement officers. And in case 25 CR 005779J, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation? Did you hear my question?
Yes, sir. Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Pitts. Good luck to you, sir.
Thank you, Your Honor. And that concludes my business before the court today. May I be excused?
Ms. McLeod, I have down that you represent the person on our DV bench warrant calendar, Mr. Zapata. Are you aware of that?
Yes. And I do represent him. I didn't know, I thought he was going to be down here at the courthouse, but he's actually on, okay. Yes.
Okay, so do you have his information? If you want him to jump on.
I do have his information, Your Honor.
Okay, so if you want to see if you can jump on early for us, and I'll try to work him in so that we can release you, okay?
I will do that, Your Honor. Thank you.
All right, thank you. Okay, yes, courtroom 2. Who do we have next?
We have position 13, Mr. Huggins.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Huggins. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir?
Good morning, yes, sir.
Thank you. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Ms. Huda.
Yes, Your Honor, the recommendation in this case is 12 months to serve, 88 days, credit for time served. The balance to be served on probation, we're asking for a BHET a stay away from the Ponce Presbyterian Church located at 163 Ponce de Leon Avenue in Northeast Atlanta. We're asking to leave restitution open for 30 days for a broken window, but we understand if the court isn't going to do that. And then finally, 40 hours of community service.
Okay. When's the last time you were in touch with do you know whether or not your victim advocate has been in touch with anyone at the
church?
At the church?
Yeah, I will check that out. So it looks like we did talk to them back on the 11th. I'm guessing they're going to put the broken window through their insurance carrier, and the likelihood of Mr. Hudgens paying for the broken window is unlikely. So quite frankly and realistically, we would be rather have the court focus on the community service that he do somewhere not the church than the restitution, Your Honor.
Okay, so I won't order the restitution, but I will accept the rest of the recommendation.
Thank you.
Thank you. Anything further, Mr. Rogalski?
Yes, Your Honor. Just briefly, we would just ask, Mr. Hudgens is residentially challenged. We would just ask if the probation fees could be waived for quite literally as long as you will allow, and then that probation may terminate upon completion of the conditions.
Okay.
Yeah.
Mr. Hudgens, it's my understanding that in case 25 CR 005225B, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Very much so.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Can we get a social worker to give him some information regarding housing to assist him? I am going to waive the probation fees while he's on probation to help him stay on his feet. And when you complete the terms of the probation, Mr. Hudgens, I will have it go to a non-reporting status. So you'll still be on probation, but won't have to pay those fees, okay?
Yes, sir.
All right. Good luck to you, sir.
Yes, sir. Thank you.
You're welcome. And courtroom 2, do we need a Spanish interpreter this morning? I see Ms. Lucia on the line.
No, sir.
Your Honor, my client is a little bit challenged. I think he might need an interpreter.
Oh, okay. Okay, that's fine. And were you able to raise him, Ms.
I
McClellan?
was, Your Honor.
Okay, thank you.
You're welcome.
Who do we have next?
We have position 19, Mr. Peacock.
Yeah. Could we hold Mr. Peacock?
So I believe earlier, Mr. Rogalski, you were telling me that one of these charges does not have a bond associated with it at the present time. Is that right?
Your Honor, to my understanding, and from the notes that my supervisor had granted us as well, the 25 CR 006090J case was originally a 25 PI 006860. And then it had been transferred down to state court. And from his notes, he had stated that there is no bond on that case. Now, I have not been able to access Odyssey, but I am inclined to believe that, of course, if he had put it in there. So to my understanding, yes, Your Honor, there is no bond on that case ending in 6090.
So that's 2 counts of willful obstruction, fare evasion, and possession of marijuana less than an ounce. Those charges?
Yes, Your Honor.
Okay. And Ms. Lewis, do you see any bond associated with those cases?
What position number are we on? I'm sorry.
Position 19, and it's the add-on 6090J.
Okay. There's no bond amount set for the fare evasion with the event of August the 22nd of 2024. Possession of marijuana less than an ounce, August the 22nd of 2024. So those 2 do not have bonds associated, those 2 charges. Everything
Okay.
else he has only has a bond.
Ms. Evans Battle, your bond recommendation, please, and if I take that this has something to do with him being at MARTA.
Yes, Your Honor, and for, we would ask for surety bonds is his current status that he would have to have a surety bond. So it'd be $500 on the possession of marijuana charge and $250 on the fare evasion. They would be surety bonds.
And the obstructions?
The obstruction, it's already, there's a bond set in the amount of $1,000 as a
Both of
surety
them?
bond.
Per charge?
No, just for that.
So I have 2
Yes,
counts of willful
for
obstruction.
each one of them.
Okay. Okay, Ms. Washington, could I get Mr. Peacock's history, please?
Yes, Your Honor, just give me one moment.
Okay.
For Mr. Peacock, there are 17 arrest cycles. The last arrest was in September of this year for willful obstruction, theft by shoplifting, possession of drug-related objects, possession of a firearm, and possession of dangerous drugs. That case appears to be pre-indicted. There's also a 2024 felony conviction for fleeing, 2017 felony conviction for 2 counts of entering auto, a 2016 felony conviction for aggravated assault out of Muskogee County, and also a 2015 misdemeanor conviction for hit and run, and a 2014 felony conviction for possession of a firearm. Nothing further.
Thank you. Mr. Rogalski?
Yes, Your Honor. Come before you is Mr. Peacock. He is 33 years of age. He's a lifelong resident of the Atlanta area. He's been living here for his whole life, and his whole family is here too. He's got 5 children. He does also have a child with a lot of different medical issues. His son just got out of surgery, in fact. And unfortunately, he is suffering from some pretty severe medical issues himself recently. During his time in the jail, he's had severe stomach problems, high blood pressure. I believe he had just gotten an x-ray and is still waiting on a diagnosis for why his back has been really bothering him and his stomach has been bothering him recently. Judge, he does help his mother with home care. He does DoorDash for a living, but he does also have his GED, so he has some good employable skills. And he does have a good address to go back to live with his mother. That is not the address of the incident location. And that address is 100 Green Valley Drive, and that would be in Fayetteville, Georgia, where he would reside with his mother and family upon release. So, Your Honor, we would be asking, given the fact that he is kind of tight on money at the moment, and of course has a lot of people to take care of, we would be asking for, on the possession of marijuana and fare evasion, a signature bond if he is eligible. And then if we could get those counts 3 and 4 for the willful obstruction down to no less than $1,000 in total surety bond, that would be our request as well. Thank you.
Can someone tell me what his bond is on the battery family violence charge?
That's a $7,500 bond surety on the battery family violence. And the willful obstruction, a law enforcement officer, 1,000. There's only one willful obstruction on his booking screen for the date of 9/27/2025.
Okay, so,
Would the
Mr.
court,
Rogowski.
like to
go
hear
ahead.
any, facts about the case and why the bond is so high? I'm not sure if, you were the judge who set the bond.
Well, I am only giving him a bond on those 4 other charges. I'm not
Okay.
I'm not changing the bond on the
All
battery
right, then.
family
I thought
violence.
that was what he was asking you for.
Okay,
All right.
so
Thank you.
he already has that bond, and I take it that since he was at one, I don't know if he made it or not, but as far as these 4 charges go, Mr. Rogowski, if you can take it down and present the bond order to me, it'll be a $250 bond per charge, makes for a good bond, makes for $1,000 good bond. Stay away from MARTA at the 5 Point Station. That's 30 Alabama Street. No drugs, alcohol, weapons while out on bond. Okay.
Yes, Your Honor, just so I can read that back. So it is $250 surety bond on each charge for a total of $1,000 good bond. A stay away from the MARTA 5 Point Station. No drugs, alcohol, or weapons while on bond.
Yes, correct.
All right, thank you, and I will present that order after court.
Very good. Good luck to you, Mr. Peacock.
Good morning, Your Honor. I am so sorry to interrupt, but I might be needed in another courtroom. Is it possible that you could take the case if you still need the Spanish interpreter, please?
I do. He is on. Miss McLeod, did your client say when he's going to jump on for us?
I was under the impression he should be on now, Your Honor. I did tell him to log in, and he said he
Okay.
would.
Madam Interpreter, if you could sound for Byron
Coming on now.
Dominique.
Zapata.
Is it better?
He's coming on now.
Oh, okay. And can we go ahead and take this the DV bench warrant calendar? Are you going to be representing for the state, Ms. Evans Battle?
Yes, Judge.
Okay. Good morning, Mr. Dominguez. I'm Judge Eric Morrow. This is the DV bench warrant calendar. Can you come on with me, sir?
Señor Domínguez, buenos días. Yo soy el juez Morrow y este es el calendario para su caso el día de hoy. ¿Puede prender su cámara y su micrófono, por favor?
Muy bien.
Yes,
Buenos
very
días.
well. Good morning.
Yes, Ms. Evans Bell, it's my understanding that Mr. Dominguez missed a court date.
Yes, Judge.
De lo que yo entiendo, pregunta si es que usted no llegó a una corte que tenía una cita. Le indican que sí.
Sí. Sí, no,
Yes,
no fui.
Hold
Yes,
on,
I
Mr.
can
Dominguez. Ms. Evans Battle, when and where did he miss the date?
It looks like a calendar. He failed to appear on September the 4th of 2025. There was a notice that was sent to a 2030 Esquire Lane. That address is actually different than the address that I have in our system. Let me find it again. Because I have a Woodstock address, 101 Pioneer Drive in Woodstock. And I'm not sure which one is the address that is his address.
The Pioneer Drive is his address.
The notice was not sent to that address.
What is the address that's in our system that he should receive notice at?
It's Pioneer Drive, Your Honor. I'll look at the exact
Yes, it's 203 Esquire Lane is where it was sent, but it should be 101 Pioneer Drive in Woodstock.
That is correct. Zip code 30188.
Thank you.
You're welcome.
So since, Ms. Lewis?
That was just updated when he came and got his case reset, Judge. His notice did go to the last address, the 2030 Esquire, but he came in and got it updated as of October the 3rd. That's the new address, is 101 Pioneer Drive.
Okay.
Okay. So, so now, if we can interpret this, Madam Interpreter, Mr. Dominguez, it's your responsibility to make sure that when you move, that your address is immediately updated with the court.
Señor Domínguez, es su responsabilidad asegurarse que cuando usted se mude, su dirección está, la cambie y esté actualizada con los tribunales.
It's my practice that I will
Muy bien.
It's my practice that I will set aside a bench warrant on one occasion, but if you miss court again, I'm not going to set it aside the next time. You understand?
Lo que es mi práctica como juez, que yo le voy a quitar esta orden de arresto que tiene usted contra suyo, yo quito eso una sola vez, pero esto no puede volverse a repetir. ¿Comprende usted?
Muy bien.
Very well.
So I'll set this bench warrant aside this time. Good luck to you, sir.
Okay,
Thank you, Your Honor.
esta vez le quito su orden de arresto. Es la única vez y su caso está terminado. Buena suerte.
Ya está terminado.
Is the case over?
No.
No, the bench warrant was set aside. You need to come to court the next time you get a court notice. Otherwise, you're going to get another bench warrant, which will not be set aside next time.
Perdón, el caso no está terminado. Es esta orden de arresto. Se la voy a quitar. Eso quiere decir que tiene que presentarse en la siguiente fecha de corte que le den. Si no se presenta en esa, le vuelven a dar otra orden de captura y no se le va a quitar eso, pero tiene que presentarse para su caso.
Muy bien, ¿está bien?
Okay, very well. That's fine.
Anything further, Ms. McLeod?
Nothing further, Your Honor.
All right, thank you. So we appreciate your help, Madam Interpreter and Mr. Domingo. You have a good day. You're free to go as well.
Señor
Thank you, Your
Domínguez,
Honor.
Señor Domínguez, puede desconectarse. Thank you, Your Honor. You have a good afternoon.
Thank you. I appreciate it.
And Your
Una
Honor, that
preguntita.
concludes my business before the court today. May I be excused?
Yes, have a good day, Ms. McLeod. Thank you.
Thank you, you too.
Disculpe,
Mr. Dominguez?
Yes.
disculpe.
You're free to go, sir.
¿Me escuchan?
Yes. Do you have a question?
Solo
You
una
can text me. Or call me.
Una preguntita. Una pregunta.
Okay, Mr. Dominguez, the interpreter's gone. So Ms. McLeod, if you'll be able to communicate with him.
Yeah. Send me a text message. Or call me.
Ms. McLeod, he just said he has one question.
Of course. Yes, I can, answer any questions he has.
Well, we don't have
Una
anyone
pregunta.
that can translate.
Más o
The
menos para
translator
cuándo
is
tengo.
gone. The interpreter is gone, so there's no way to communicate.
He can ask me in a text message. He usually asks me in text messages.
Well, he doesn't seem to understand that, Ms. McLeod. So, all right, well, he's gone. Have a good day, Ms. McLeod.
Thank you, Your Honor.
Who do we have next?
We have position 17 and 18. Mr. Mason.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Mason. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down, Mr. Mason. Yes, Ms. Evans Battle.
Yes, as to 25 CR 001271E, count 1, 12 months, served, 26 days, credit for time served, balance probated, no further contact with Mahik Kamani, participate in the OP 21 law and decision-making course, complete 40 hours of community service. Count 2, 12 months probation concurrent with count 1, that he stay away from Northside Hospital unless he has a bona fide emergency. We ask they stipulate to venue, identity, and a factual basis for the plea, and the state would move to non-pros 25 FTA 001922.
Rogowski?
Yes, Your Honor, we do so stipulate to factual basis, identification, and venue for the purposes of this plea. Your Honor, we do ask that you accept this plea on Mr. Mason's behalf, as well as I do know that he is having some financial struggles at this moment. So we would just ask if probation fees could be waived again for as long as Your Honor will allow. And that he did assure me that he would be able to do the Operation 21 law and decision-making course. However, he said that would probably be best as soon as he is able to start working again. So we would ask for at the very least 3 months for him to get started on that, if there is a time limit that's going to be imposed.
Okay, Mr. Mason, it's my understanding that in case 25 CR 001271E, you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Medication.
And that medication does not, you said you're on medication?
So I start cardiac medication.
Okay, and that doesn't affect your ability to enter into this plea, is that correct?
No, sir.
You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Mason. I will waive 3 months of the probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. So if you get it done within that 3 months, you're not going to have to pay any additional fees, okay? So the sooner you get it done, the sooner you're not going to be on reporting probation, all right? All right, good luck to you, Mr. Mason. And my understanding that position number 18 is going to be null pros, Ms. Evans Battle. Is that correct?
Yes, Judge.
Let's see. The add-on 4, do we have that person? Or
He's downtown, Judge. We're gonna need to reset him to 1021.
okay, so 1021. And the only one that we are missing, are we missing anyone else aside from Mr. Murphy's client, Mr. Buford? Have we gotten everyone?
I believe so, Judge.
Okay. Ms. Lewis, can you text Mr. Murphy to see if he's going to be back with us? If not, we'll have to reset Mr. Buford until Thursday.
Okay, let me try to call him if he can answer the phone. Let me text him.
Okay, thank you. And I don't see that that the other court is with us. Where was he at?
South Annex. Oh, yeah, he was at South Annex.
Right. So I don't see South Annex still on with us, so I'm not sure if he's available or not. While we're waiting for that, Ms. Grace, can we go over the calendar?
Yes, sir. We're ready?
Yes, ma'am.
Okay, position number 1, reset further notice. Position number 2 and 3, reset jail jury, along with position number 4. That, yes, along with position number 4. Position number 5 was a plea. Position number 6, reset 1021. Position number 7, we are holding. Position number 8 was a plea. Position 9 was a plea. Position 10, 11, and 12 were pleas. 13 was a plea. 14 was a plea. 15 was a plea. 16 non-pros. 17 was a plea. 18 non-pros. Position 19. Bond remains the same, reset jail jury, and his other case, 25 CR 006090J, was an amended bond of $1,000 good bond. Position 20 was a plea. Position 21 was a plea. Position 22 was a plea. Position 23, jail jury. Position 24, reset 12/18/25 SAP calendar. Position 25 was a plea. Position 26, reset 10/21/27 along with position 27. Add-on calendar, position 1 was non-pros, was a plea, with non-pros. Position 2 was a plea. Position 3, reset 10/21 SAP. Position 4, reset 10/21 SAP. Position 5 was a plea. Any questions, concerns?
I got 26, you said reset 1021, that's transferred?
But since we don't have the transfer order, we have to reset it first, Mr.
Fair
Wong.
enough. Makes sense. Your Honor, that concludes our business. May we be excused?
Yes, have a good rest of your day. See you next week.
Thank you, Judge.
Thank you very much, Your Honor.
Thank you.
Solicitor Battle, and thank you very much, Solicitor Doc.
Because he's still in court, I don't think he's able to answer. To be on the safe
Okay.
side, since he already has that other case reset to Tuesday, I think it'd probably be best we set the other case to Tuesday.
Does the person have anything holding him aside from this case? Do you know?
Let me see.
Because if he doesn't, I don't want him to sit in jail for a whole week.
Well, I can also say that like the offer is going to require more jail time anyway, so.
Okay, okay. So yeah, let's.
You know what?
Thank you.
I hope and pray that Mr. Murphy will be able, let's see. Okay, Mr. Murphy, I don't know if he can do double standard because the other case, if it doesn't get transferred to Superior Court, he can't represent this individual. He's still on Mr. Bruford, the one that we assigned him to, Mr. Williams. They're all in the same scenario.
Okay, do we have
They're all
somebody
in
else that we
scenario.
can, do we have anyone else that we can ask? Is Miss Watson Cafe still?
That's the whole thing.
Oh, I thought she stopped taking as many, or Will Kelball?
Yeah, I don't, to see, I guess he would, well, I guess he will not be able to represent him. Because he's already representing Mr. Buford on the same scenario with the escape case.
Well, let's see if we can find another conflict attorney between now and next Tuesday.
Okay, but Mr. Buford, he's not going nowhere.
And Ms. Lewis and Judge, Mr. Murphy is listed to represent Mr. Buford.
Yeah, I know that he represents, but we also asked him to
Yeah, but I
represent
know
Melvin Williams
Yes.
on the third, but he's also involved, but I don't know if that other case for Melvin Williams is gonna be transferred or not.
Yeah.
But he.
Okay,
he still has
well,
to-
let's just see if we can work that all out by next Tuesday.
Okay, so in the meantime, South Annis just came back on, Judge.
Okay, so appreciate you coming back on with us, Sergeant. We're gonna reset Mr. Buford until next Tuesday.
Yes, sir. Next Tuesday for Mr. Buford.
Yes, yes, thank you very much. I appreciate it.
No, thank you.
Okay, all right, y'all have a good rest of your day. We'll see you next time.
Excuse me,
Thank
Judge,
you.
what are we doing
Yes.
with probation revocation here in county?
I wasn't aware of a probation revocation calendar.
Yes, sir, I'm
See it
sorry.
now, and yeah, there
Yeah.
is one. Matter of fact, it has 3 defendants on it.
Yes, that's correct, Your Honor. We have 3 defendants.
Okay, well,
See,
apparently nobody else was
Um,
aware because they would have, they would have brought them. Or had somebody represent them. Apparently the PD's office wasn't aware as well. Can we reset those until Thursday?
Oh, this is gonna be awkward. Oh, that's a big kind of, we already. We got a judge, oh Lord. I don't know what happened, why nobody got the calendar. I wasn't here, I just came back from vacation, so I don't know what the transaction was with that calendar going out. Unless Miss Grace have any information on it. I don't know if it was late or it was a last minute add-on situation.
Well, regardless, apparently we didn't get it or they didn't get it, so we're gonna have to,
Well, I
we won't be
guess,
able to handle those today, so when would we like to handle those?
And the 21st has 55 cases.
Well, are any of those probationers, are they in custody?
they're all in custody, Judge.
Okay, I don't want
know
them
if they're-
sitting,
I don't know if
so,
they're asking,
well, I don't want them sitting if they are, so can we put
Well-
those on Thursday?
well, yeah, I guess we'll have to.
Yeah, because Your Honor, because one guy, he's been sitting since August the 5th.
Okay, let's put those cases on Thursday. I'm sorry that we didn't get the calendar, so. Thank you, Miss Allen. I'm sorry that we weren't able to handle those today.
No worries, Your Honor. Well, that concludes my business. May I be excused?
Yes, we'll see you next time. Thank you.
Thank you.
All right. Anything else? If not, y'all have a good rest of your day. I'll get those signed when you get them to me.
All right then.
Miss Grace. All right. Thank y'all.
Yeah, I gotta send them over.